Let's see. Dane began land surveying in 2005 and knew he was going to be a surveyor on day one. He loved the ability to be outside, perform historical research, perform mathematical computations, meet landowners, cut land, investigate, and assist with legal matters, and learn new equipment and technology. Dane received his land surveyor and training certification in 2007, subsequently became a land surveyor, professional land surveyor in the state of Maine in 2009. Dane is currently licensed in not only Maine, but also Vermont, Texas, Colorado, and Oregon. In all, he's gained 15 years of experience working in many different states and also many different survey disciplines, including residential, commercial, ALTAs, energy sectors, transportation, which he now works for. Oh, it comes up here in a second. He works for Colorado Department of Transportation as a professional land surveyor as well. So Dane is always gracious enough to, we've been kind of doing the first of the month as it pertains to like the FS, the PS, and CST exams. And so Dane has another one this week on rules of construction. So as always, we appreciate Dane's time and support. And for those of you, I'll throw in the chat, he's got a video series that we did with the Western Fed, which you might have all seen on that email. Western Federation of Professional Surveyors. We did a video series based on Dane's manual, and then I'll also throw Dane's manual in. There you go. There's Dane's manual. If you don't want the video side and you just want to go through the manual, you can get that from his Shopify or Amazon or anything. So cool. Yeah. I appreciate it, Dane, as always.
Yeah. Yeah. As always, thanks, Trent. And I can become available for the upcoming weeks as well with those other topics. Yep. And if you ever hear of a topic that, you know, multiple people are asking about, I'd love to try to put something together for you. So if,
yes, sir.
If you ever hear anything, just spread that on to me.
Yes, sir. Thank you.
All right. Yeah, well, with that, I'd like to say welcome everyone, and I guess we can get right into it. So like Trent just pointed out, I do have my license in both public land states and meets and bounds states. These rules of construction are, I don't want to say they're more useful in meets and bounds states, but this is all you really have to go by in meets and bounds states. There is no there's no public land system to fall back on with its mathematics and rules and manuals and all that. In meets and bounds, you're kind of out there on your own, and you're living your survey life by these rules. Okay. That's not to say the rules are not applied in public lands. All I'm trying to say is that in public lands, you have other means to try to get somewhere. And I'll explain what I mean by that. So first off, what are the rules of construction? These are rules. It's a hierarchical set of rules that are put in place to help you establish new parcels and to assist in the reestablishment of previously set boundaries or parcels. So if you're going out there and you're looking to rebuild the boundary on a parcel of land, you're going to have to apply the rules of construction in some way, shape, or form. Sometimes they're very easy to apply, and I'll get to that here in a second. And they're easy to apply whenever everything falls into place and you know the intent of the original surveyor and of the subsequent surveyors. So what I'm getting at is, if you know the true intent of the previous surveyors, whenever you're looking at a boundary, you really should not have to apply the rules of construction. Because if everything is laid out, the intent is perfectly displayed and understood by all, then why would you apply rules of construction when you really don't need to build anything? So you got to think of it that way. You're given a job to reconstruct a boundary. Now that boundary may not need to be reconstructed. You just have to redepict it in some way, shape, or form. And the way that happens is if the true intent of the original surveyor and the landowners involved is known. Now, how is the intent truly known and clear? Well, there's no ambiguities at all involved. So there's two types of ambiguities. I think I get into that. Yeah, I do. Latent ambiguity and patent ambiguity. We'll get into that in just a second. But if something is well known, there's no ambiguity. It's quite obvious what's going on and what the intent was. Then you are done. You do not have to apply rules of construction. Okay, all you got to do is read the face of the deed, and you're finished. Now, there's a lot of time where that intent is not fully known. Maybe it's, almost completely known, but not quite. Sometimes you have no idea what's going on. There's all kinds of ends of the spectrum that you could go on with that. But if there's any uncertainty, or if something is not too obvious, if there's ambiguity involved, then you might have to start applying these rules of construction. Okay, so let's get into what ambiguities are. Ambiguities are something that will cloud that intent. That's what presents its ugly head, is an ambiguity whenever you're reading a deed, and you have to decipher and make your decision on what the hell they meant by that. What did they mean by John Smith's rock wall? What did they mean by trying to think of Henderson Creek? Okay, did they mean the center line of Henderson Creek? Did they mean the edge of Henderson Creek? Did they mean Henderson Creek in 1953, or did they mean Henderson Creek in 2022? There's all kinds of situations where you can kind of second guess yourself. You don't really know the intent of that original surveyor or the landowner trying to transfer that land. The two types of ambiguity that are going to present themselves are latent ambiguity and patent ambiguity. Patent ambiguity, the way I remember this is because I could never remember it, and I finally came up with something that now I can. Patent, the letter P in patent should also jog your memory for print. Okay, so patent and print, P and P. So patent ambiguity is whenever you're reading that deed, the ambiguity is depicted right on the face of the deed. And just by you reading the print of that deed, you know the ambiguity is involved. An example of that is the example I gave here. If you're reading meets and bounds and it says north 30 degrees, 25 seconds north, a distance of 223 feet, this is obviously not right. You cannot go north-north. You can either go northeast or you can go northwest. So whoever wrote that deed, there was an error here, okay? They wrote the word north twice. They should have written east or west. So now that presents a problem to us, because now we're saying, okay, do we go north 33 degrees east or do we go north 30 degrees west? So now you got to try both of those situations out, see how the deed closes out, see which one makes more sense. You're trying to figure out what the intent was originally, okay? So that's a patent ambiguity. It's an obvious ambiguity. It's something that's right in the print of the deed. The other type of ambiguity is called latent ambiguity, and it's less obvious. So you might read a deed and it's going to say, if you go to my paper now, starting at a point on the north right-of-way line of Highway 27, let's say, okay? Thence 100 rods due north to the center line of Vanilla Creek, all right? So now you got your creek, and it called for 100 rods due north, all right? And then you go and it says follow the center line of Vanilla Creek to a point, thence south along lands of Smith It doesn't give a bearing. It doesn't give a bearing or distance. It just says along Lanza Smith, back to the north right-of-way line of Highway 27, thence along the north right-of-way line of 27 in a easterly direction back to the point of beginning. Okay. So whenever you read this, what I just dictated to you, it all makes sense. You start at the point of beginning on the north side of the road, you go up to the creek, follow the center line of the creek to Lanza Smith, go south along Lanza Smith to the road, along the road back to point of beginning. Everything looks right. Okay. Well, let's say you get out there and you locate this monument, and then you start walking 100 rods. Okay. Which is 1,600 feet. One rod is 16 feet. And you walk your 1,600 feet and it's the middle of a pasture. All right. There's no creek at all, but on that 1,600-foot walk, you crossed a creek almost right away. You crossed a creek at 160 feet. Okay. And then you just kept walking, and now you're in the middle of nowhere. There's no creek involved. And then you start walking this way and you realize Lanza Smith is way down over here. You're like, well, what the heck's going on? Okay. Well, someone added an extra 0 in that deed. It really should have been 10 rods. You should have crossed that creek at 160 feet as opposed to 1,600 feet. So now that's a latent ambiguity. You didn't know that extra 0 was written in there until you went out in the field and you field verified it. Whenever you compare that deed to the real situation in the field, that's when the ambiguity pops out. Okay. Until then, it all looks good on paper. All right. There's a rule, they call it the 4 corners rule. And what that rule is, basically it's saying you got your 4 corners of the piece of paper of your deed. Okay. Whatever's within the 4 corners of that deed, that's what you need to be going by. You're not supposed to look outside of the 4 corners of that deed, of that piece of paper, unless intent is not known or ambiguities start to come into play. So if I were to take that deed and uphold that 4 corners rule, when I read this, I would have not seen this. But I could have gone into Google Earth and looked to see where Vanilla Creek was in comparison to the road. You know, I could have gone outside of the 4 corners of this deed to try to figure out, get my bearings a little bit more situated before I go out in the field. I just wanted to bring that rule up. And that's the rule that states you're supposed to really be looking at the deed and nothing else. But that only works if there's no ambiguities. And sometimes you don't know there's ambiguities until you go out and figure it out, right? So those are the 2 ambiguity types: latent, which is not obvious, you only find out once you go out, and patent, which is on the print of the deed. Okay. So these ambiguities, these are what's going to steer us away from knowing what the true intent of that landowner and the surveyor, original surveyor, and the subsequent surveyors was. This right here is what's going to stop us from knowing that. Okay. So the rules of construction, remember I said it was a hierarchical set of rules. And these are the rules right here. These are the items that you got to follow by. Number 1, and paramount to everything else, is intent. If you know the intent and it all makes sense, both in the field, within the 4 corners of the deed, talking to the landowner, talking to the original surveyor or subsequent surveyor, if you know the intent, you do not need to go any further. Everything is going to be known, and you can still go and verify all these, and that's what you're going to have to do. But as far as applying rules of construction, you don't need to build anything. It's already built for you, and it's sitting right there for you just to interpret it. Okay. Oh, actually, wrong word. You should not be interpreting anything. You should just be, I don't know what the word would be, like just carrying on what's already established. Okay. Next is original location. So you might not know exactly what they meant by that call in the deed, but based on the evidence out in the field, occupation lines, you can determine that original location. And we're going to get a little bit into location versus monuments, or corners versus monuments. That corner, that rebar with the plastic cap on it, that rebar is marking the corner. Okay. The monument, that rebar is not the corner. It's just an indicator of where the corner is. The monument marks the corner. Okay. A lot of people don't truly understand that, but that's something that you really need to really drive into your head, that the monument is just the signal or the indicator of where the true corner is. The corner is the property corner, and that's what people own up to. Now, the rebar is just marking it. Okay. So now we're going to get into monuments. That's tertiary on the list. Monuments are, they're going to be the indicators of where that corner is. And there's a whole set of rules and applications that you can apply when interpreting monuments to figure out if they're truly marking the corner or not. And we're going to get into all those. Fourth is measurements. If you get out there, you do not know the intent of anyone, you cannot find the original location, there are no monuments for you to find as witnesses, marking anything or nothing. The next thing you have to rely on are measurements. So now we're getting into pretty scary territory. Okay. At this point, once we start using measurements, we have no remnants pretty much of anything that anyone has done up until that point. That's why if you're using measurements, it really should be your last case scenario. Okay. Everything else, you should have exhausted a lot of other avenues before you start doing mathematics and figuring out distances and angle and all that kind of stuff. Okay. And then lastly, if you have nothing else to go by, you're going to have to use area. And I hope you never have to. That's the worst and least accurate, the scariest, the scariest option you got here. Okay. So intent, original location, monuments, measurements, and then finally, lastly is area. Okay. So intent. Intent is the true meaning as derived from the words of the document. Intent requires no interpretation. The meaning should be obvious and has no ambiguities. If you know intent, go no further. Okay. There should be no you don't have to apply your opinion. You don't have to interpret anything. It's all laid out right there for you. Who establishes the intent? The intent should be in the written document. Back to our four corners rule. A well-written description should display and illustrate one's intent. Okay. That's why it's so important to write legal descriptions in a comprehensive, correct, accurate, non-ambiguous manner. And the other thing I want to point out there is the grantor is the party that is given that responsibility. It's the grantor's property. It is he or her, it's her obligation and responsibility to get it right. Okay. They're going to hire a surveyor, and the surveyor is going to use their expertise. But at the end of the day, that grantor is going to be held liable, depending on the type of deed. But they're going to be held liable for what's written in that deed, and is specifically in that legal description. Okay. And if there is any ambiguity, the favor in the court is going to be given to the grantee as opposed to the grantor. So the judge is going to decide. He's going to have to make a decision on what that intent was. And when he does, he's going to give it in favor of the grantee, not the grantor. He's going to give it in favor of the seller, of the buyer, not the seller. Okay. All right. Original location. Original location is the location of the boundary at the time of its creation. So we have a parcel of land, big, huge ranch. Okay. And monuments were set back in 1853 by the original survey. Okay. And then over the course of time, that ranch gets divided up, sold to the heirs, all kinds of stuff's going to happen. Okay. Subdivisions are going to be made. But at the end of the day, those original monuments that were set, they're going to dictate everything within inside this larger ranch. And it's going to keep getting smaller and smaller and smaller and more divided. Every time it gets divided, there's going to be a new original monument. Every time a pin is set or a piece of land is cut apart, anytime there's a new parcel involved, there's going to be some new pins that are put in the ground. Those pins are going to be noting a property corner. And when those corners are set, that's going to be the original location for this new parcel. Okay. And it's your job as a surveyor to go out and build that back in. And that's what's meant by the intent. You know, the original intent was to have this large ranch and then to sell off the south 20 acres of the east 35 acres or whatever it is in the deed. Okay. And then we already went over corner versus monument. Remember, corner is the corner. The monument just illustrates where that corner is. Okay. A monument simply marks the corner, but it is not the corner. Okay. So try to remember that. Monuments simply mark a corner. Documents state the original location and the surveyor finds it. So all the surveyor has to go by are those documents that the original surveyor and the subsequent surveyors produced, whether it be maps, plats, legal descriptions, whatever the case may be. Those documents are what has to be used to recreate what the heck happened here. The reason those documents are important is because they're written. And that's what courts and the rule of law are going to go and fall back on, are these written contracts between all these landowners. Statutes of fraud. So that's what the judge and the lawyers are going to lean on solely whenever they're trying to recreate the picture of how this parcel was generated. They're going to go back and they're going to look at all those written documents, whether it be map form, legal description form, whatever it may be. Okay. But in those documents, that they're searching for the intent, and the intent is going to dictate that original location. Okay. So if you go back to here, really, if you're relying on area, you're going to have to build the measurements back in to recreate that area. And to get the measurements in, you might have to go get monuments outside of where you are or something. But at the end of the day, if you're way down here on the hierarchical list, you're going to have to build yourself all the way back up to this intent. Think of it that way. You might be down here, but you need to end up here. You need to find that original intent. All right, so intent is paramount. Then we go to original location, and you find that out by the original documents and what was intended by those surveyors and land transfers. If you cannot find that original location, then you're going to have to start relying on the monuments. And those monuments are hopefully marking corners. And that's what we need to figure out, okay? I want to go back to this operative record. So the operative deed is that which creates the line. The monuments represent the original line. So the operative deed is going to be that deed that created a new parcel, okay? Yeah, I just wanted to make sure y'all saw that. All right, so now we start building in. We're going to dive deep into those 5 topics. Intent is pretty much intent. You don't have to worry about what that there really is no slide on intent. It's just the intent. Then we get into the original location. Original location, what the big takeaway there is, you really got to memorize that the original location is dictated by the documents that created those parcels. Because again, that's what the courts are going to lean back on. So now we're going to start. Now this is where our interpretation of things is really going to kick in. And the third thing in the hierarchy is monuments. Okay. So there's going to be different types of monuments, different conditions of monuments, whether they're recorded or not recorded. So let's go over those. So just like there's a hierarchy overall, within monuments, there's a hierarchy for each type of monument, okay? So there's natural monument. Let's go to material first. Like, what are these monuments made up of? Natural material, that would be something like a tree or a boulder, a creek, something like that, okay? Not man-made. Those types of monuments are paramount. They hold more than any other monument, any other material of monument. The next one is artificial, and that's man-made. That's where your rebar, your cut granite, iron rods, PK nails, right-of-way markers, brass caps. Those are all artificial. Those are not made in nature. They're made by man, and then they're placed there. Okay. And then third is record. That refers to the adjoiner. So Smith, the lands of Smith, that would be a record monument. Okay. I do want to say here, if you supposedly, per the BLM manual and other books I've read, if you manipulate a natural monument, it then is degraded to become artificial. So if you hack a blaze in a tree, or if you chisel an X in a rock, if you're manipulating those natural features in any way, that boulder that you chiseled your X in now has the validity of an artificial monument. That tree that you hacked the blaze in, that tree becomes an artificial monument. Okay. So if you adjust if you adjust the natural monument, it then becomes an artificial monument in validity. Okay. I don't really know the reasoning for that. The only thing I could really think of would be, I guess they think if you're chiseling an X in a boulder, you have the potential to split it or move it in some way. If you hack a blaze into a tree, maybe you can kill it. I'm not really sure the reasoning for that, but I have read that. Okay.
Hey, Dane, there's one question in there. The old stone wall, natural or artificial monument?
I would say artificial, because you've picked up those stones and you've moved them to a different location and you've placed them in a pile. And that would be my assumption. And working in the state of Maine, I can tell you, everyone considers them artificial.
There you go.
And every single parcel has either a rock wall or a creek on it in Maine. So I've come across a lot of those.
There you go. And then there was one more, the rules of construction. Is this a reference to the BLM manual? That was just another one in the chat.
Yeah. This, I mean, like I said in the very beginning, this is the backbone of how you interpret evidence. So yeah, it is a big part of the manual. Again, I would, in a meets and bounds state, this is again, all you have really to go on. The BLM manual, whenever they were making their rule, all their guidelines and procedures and whatnot, they're basing a lot of those decisions in that manual on the rules of construction. So indirectly, yes, it is. Does that make sense?
Yeah, I believe
okay.
So. Yeah.
All right. So monuments, that was material. Record versus not record. So recorded versus unrecorded. A monument that is documented in the deed. So in the deed, it says, due north 100 feet to an iron rod with a red plastic cap stamped LS number 1234. And then you go out there and you find a 5/8 inch iron rod with a red plastic cap stamped LS 1234. That document said exactly what you were going to go find. Sure enough, you go out there and there it is. So a documented monument is going to have more validity than an undocumented monument. What if it just says 100 feet due north to a point? And you get there, and with your new total station, you measure it perfectly. It's 100 feet. You're hitting a 5/8 inch rod with a red plastic cap within 1/100th of your measurement. Well, I mean, that monument's there. It's a pretty good indicator that you're on the right track. But at the end of the day, that monument is not documented in that deed. It's going to hold less validity than it would have if it was documented. Okay. And then possession. So that would be like uncalled for evidence of occupation. So that's when you get to like fence lines, hedgerows, stuff like that. Okay. Those are monuments. But they hold less than undocumented, and they sure as hell hold even less than documented. Okay. This is a big one. This is something that you're going to get on the test 9 out of 10. The condition of monuments. So there's really 4 types of monument conditions. There's existing, disturbed, obliterated, and lost. And it's a good idea to get these figured out in your head, what each of them mean. So an existing monument, that's something that's called for in the deed. You go out and you find it exactly like the deed says. It's set. It's what's called for. It's not leaning. It's not rusted out. It's not hard to see or faded. It still has bright pink flagging on it. That's an existing monument. That's something that it's going to be pretty damn hard to refute, right? Now, let's say you get out there and you find that rebar with a plastic cap, but the plastic cap is cracked. Squirrels ate it and the rod's kind of leaning now. Okay. Well, you can still see the red plastic. It's still pretty firm, but yeah, it does look bent. Maybe a tractor hit it or something. It has a good solid hole, but something's just not perfect about it. That's disturbed. It's still most likely marking the corner, but it's not perfect. Then you get to obliterated. Obliterated means you get out there and there's no monument. You don't see the iron rod with a red plastic cap, but You do see a mound of rocks and a pretty hole in a rock where it looks like a rebar was drilled at one point. Okay. So the rebar is not there, but you can still see where it was and where it would be if it was there. Or even better, you find 4 reference ties to that monument. And when you measure them out, sure enough, it's going right to that hole that you found originally. So that's obliterated, meaning it's not there. You don't see it anymore. But based on other evidence, you can reasonably assume that you do know where it was located. It's going to most likely be that hole. That's what all 4 reference ties tell you. The size of the hole, it's 5/8 of an inch. It looks like it was drilled. There's all kinds of stuff telling you that, hey, this is where that monument was. Okay. Even though it's not there. And then lastly is lost. Lost is you get out there and there's no monument and there's no hole and there's no reference ties. You have nothing. It's just a void, blank slate. And that's not good news. That's when you got to start applying math or really drilling down and go and find senior deeds and stuff like that, trying to find what the intent was. But at that, in a lost corner situation, you're most likely going to have to start applying some sort of mathematics, a distance or a bearing intersect, or talking to landowners and asking them where they remember seeing the deed. There's all kinds of ways that you're going to have to try to build that back in, okay? Because it's gone and it's lost and you have no evidence of how to put it back. And then rights status. So a senior monument is going to hold over a junior monument. So the original deed calls for a 6-inch square stone. Okay. And you get out there and right on the money, you're finding a iron rod as opposed to a stone. But you see fragments of an old cracked up stone. Okay. So now you got to figure out what happened. Maybe the stone cracked apart. Maybe it fell. It was disturbed and a subsequent surveyor came in there and they tried to do what you're doing and place a monument in the location where that stone used to mark. The rebar would be junior, the stone would be senior. Okay. So first thing you do for monument reestablishment or monument interpretation is you want to find the original monument. So you want to go find the operative deed. That's the deed that created the parcel you're working on. Okay. So the operative deed is the deed that created the tract. In that deed, it's going to call for a monument, hopefully. That's the monument that you need to go out there looking for. If you don't find that monument, that means it's going to be a subsequent monument. Someone is trying to replace that original monument because it was lost or disturbed with a new monument. That new monument is going to be second in validity compared to the original. And if you don't see a subsequent monument, then you have to start relying on witness monuments. And those would be things like a reference tie. Okay. So paramount is original, then subsequent, and then finally reference ties or witness monuments. If no monuments are called for in the document, then they simply become supplemental evidence. So in your vesting deed and the operative deed, they're all calling for iron rod. And you get out there and you see a PK nail. Okay. Well, you got to ask yourself what's going on. Why did no one call for a PK nail? Why is everyone for the last 27 years calling for an iron rod? Did they put a new sidewalk in and pull that rod out? You got to ask yourself and try to figure that out. And if no one created a document stating that it was a PK nail now, then that PK nail really just becomes supplemental evidence to that rebar's location. Does that make sense? So that PK nail really, all it's going to do is kind of guide you in a direction of where that original rebar is. And that original rebar is called for in all the documents. Now you go out there and you find a PK nail. So now the problem is that PK nail really cannot hold anything. All it's going to do is indicate where the corner is. Now, I'm not saying the PK is not on the money, but you can't treat it like it's the original monument, okay? Or any other called for monument. It's just supplemental evidence. Trent, I'm not seeing, oh wait, questions.
Yeah, there's a little bit of dialogue going on in there.
Okay, yeah, if there's any, I'm not reading it as I go.
Jerry had chimed in about some human-made monuments because of the certainty and location are considered equal in rank of natural monuments. So similar to like the stone wall that we talked about. That was, or in this case, like he says, classifications will follow like sidewalks, street paving, curbs, wells, canals, concrete buildings, concrete fences. So
wow. Yeah, no, I agree. Let me see. And then Jerry. Okay. Yeah, if anyone I'll keep checking, but if you see any, I don't want to just keep carrying on. So let me know.
Yep, you're good.
All right.
We'll have a conversation type. When you're done. Yeah.
Yeah. So monument types. So there's locative monuments, there's witness or reference monuments, and then there's passing monuments. So a locative monument is locating the corner. That's the stereotypical situation with an iron rod driven in right at the center of the corner. Okay, that's locative. That's going to have a lot of validity. Next, just like we discussed here, witness monuments. Those are the monuments that they don't mark the corner. They mark locations to help you build the corner in. So that's stereotypical situation where you get your PLS corner, your southwest corner of section 17, okay? And then your record monument, or your, we call them record monuments in Colorado. I don't know what other states call them, but so it, the document shows the section corner, and it's going to show all the reference ties, 52 feet to a stop sign, and then 60 feet to a sewer manhole, and then you got your chiseled X on the curb and all that kind of stuff. All those are going to be your reference tie monuments. All those, the only purpose of these is if this is obliterated, you can drive it back in with your reference ties. So these are reference monuments or witness monuments. And then the third is going to be passing. So that's when you get a situation where you're beginning at a point of beginning, then it's north, then it's north 200 feet past the southwest corner of Harry land. Okay, so here's Harry's property. You're going to pass the southwest corner of Harry, then continuing the same bearing to the northwest corner of Harry, thence continuing on the same bearing, an additional 600 feet to the center line of a creek, thence an additional 200 feet to a stone monument at the northeast corner of said property. Okay. So all these monuments along the way are passing monuments. Okay. They're just there to help guide you up to this locative monument. So everything you're going along the way is called a passive monument. Those monuments, they're very useful in orienting you, but they don't hold as much validity as this locative monument. Okay. Let's say you go and you find this locative monument and the northwest corner of Harry is offline. Are you going to really put a bend in your line to go up to the northwest corner of Harry and then over to yours? No, you won't. The call is from the point of beginning to the stone monument. Everything that happens along the way is just a passing call, and it's trying to illustrate the direction that you're traveling. Okay. Again, I don't want to throw them out like they're not useful, because they are. And sometimes they're all you have. Sometimes you start here, you go up, you find Harry's southwest and northwest and the creek, and you get here and the monument's gone. Well, now those can be used to really prove your case in court. Like, hey, I'm going up here and I'm going to set a new monument here based on this overall distance. I found everything that was called for in that deed. So it can be useful, but they are kind of tossed aside if your intent of finding that original stone monument is found. Okay. So locative, passing, and then witness would be monuments over here to back that stone in. Okay. Let's say you get up here and the stone's gone, but you have 3 really good references. I would utilize the references before I would start using my passing calls. Okay. Locative versus descriptive. This is a big one. I'd really like to drive this home. So let's take the situation, thence to a stone in a fence line. Okay. So you go out there and you walk a fence line for a mile. And sure enough, you're finding fence posts, and every now and then a fence goes off both sides. You're in ranch land or something, and you're finding fence posts, and you get all the way up and you find the rebar that was called for. Okay. And right at that rebar, actually, let's say you get all the way up there and you find a fence post right here, not the rebar. Okay, let's go with that. So you find a fence post, but you do not find the rebar. The deed calls for a rebar. That fence post is not the corner. Now, maybe it is. Maybe based on measurements and reference ties, someone ripped out that stone and put that fence in. It's still not going to be the corner, but it's going to indicate the corner. But what I'm getting at is the call in this situation is the stone corner, the stone monument. It's not a fence. They throw this fence line comment in this call just to help guide you in the direction that you need to be. It's almost like a passing call at that point. Okay. It's called so the fence is the descriptive monument. It's not the monument. It says thence to a stone. It doesn't say to a fence corner. It says to a stone. The fence is just going to be there to help you. Okay. Let's say it says thence to a 6-inch stone in the center of Henderson Creek. Well, you're going to that stone. You're not going to the center line of Henderson Creek. Let's say you get there and you find the stone and it's here. Okay. Well, that's not the center line or the thread of the stream. Maybe the creek meandered over the years or something. You're going to the stone, not the center line of the creek. Okay. So keep that in mind. I've seen that backfire on someone before. This exact situation. They held fence corners, and the fence was just a description. Was there for descriptive purposes, not for locative purposes. All right. So we're going over the materials and the conditions of things. A called for monument is calling for the position the monument marks, not the monument itself. So I hope we understood that. Precedence goes to original, then subsequent monuments, and then finally reference or witness monuments. Monuments are controlling only if they are called for, in the same position and undisturbed, set in the condition as called for in the site of conveyance, and existent at the time of the conveyance. I was at a conference one time in Maine, and they had a lawyer doing a talk, and he got up there and he started bitching and griping to everyone. And it was funny. I was sitting right next to my boss. I've been surveying probably a year at that point. I'm sitting right next to my boss in a chair. And for that whole year, I was writing legal descriptions for him. And every single legal description he made me write, I would have to write in the description. It would say, thence to a 5/8 inch rebar set with blah, 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 stamped on it. And then in parentheses, he would make me do open parentheses. And then he would make me say to be set. Okay. So we had this beautiful description about what the bearing in the distance and what was going to be there. And then he clouds it all with parentheses to be set. And I didn't know any better. That's what I was doing for a year, you know? And this lawyer gets up there and he's like, if I see one more person tell me that, you know, their description is written before they start putting the monuments in the ground, he said it's totally non-valid at that point. And he's right, because now my boss's description was going to sit out there for the next 50 years, and people are going to read that and be like, well, is the monument set or not? You know, like, I don't understand. Is the monument there or not? And then the lawyer said, you just soon be calling it a unicorn horn at that point, because it's that fictitious. It's that imaginary. So basically what he was getting at was, if it's not in the ground when you're writing that description, I would recommend holding on to that description until it's put in the ground, or give it away and go set those monuments as fast as you can. One way or the other, but don't keep telling everyone it's not there yet, because we don't know when you're going to put it in. Okay. Well, that's this one right here, existing at the time of the conveyance. So when they're selling that land, you would think that grantee would want the pin set when they bought it, right? Well, that's what it's saying. And it needs to be in the condition that is cited. So, you know, you can't say a 5/8 inch rebar and it be a 1/2 inch rebar or something like that. Due to the assumption of impartiality, public sector surveyor monumentation is considered a little bit higher than private sector. So what this is saying is, you know, DOT surveyors monuments, they're paid for by the state. They're state employees. They represent the state. Therefore, their monuments are better. And I am a state employee. I don't necessarily agree with that at all. But I do see the idea behind it. You know, it's taxpayer money. They're doing it truly for the good of the public. They're not a private sector surveyor getting paid under the table to do something fishy or something like that. So there is more validity given to public sector surveyor monumentation as opposed to private sector. And we've gone over all these: natural over artificial, called for over uncalled for, locative over passing, documented over undocumented, and locative versus descriptive. Okay. There are exceptions to everything we just talked about. Okay. Disturbed monumentation loses all or some validity. So yeah, it might be called for on the deed, but I mean, is that monument pulled out of the ground and laying on the side? So yeah, it might be called for, but you got to think, is it truly, can it really be relied upon? Monuments will not hold if the grantor's intent clearly states otherwise. So you could have a deed in front of you that's depicting everything in that deed. You go out and you find it. Okay. But you have that whole latent ambiguity thing going on. So let's say the intent was to set the monument at 1,000 feet. And that was the intent. You go out and that surveyor, he misunderstood, and he resets another monument at 100 feet. Okay. Just because it's a called for monument in the deed doesn't mean it's always going to hold if it doesn't make sense with the whole greater picture. So you got to look at the whole description and make sure that it all makes sense with what you're finding. Just because it's called for doesn't mean that that was the intent. So this goes all the way back to what we first discussed. Is that intent clearly known? If it's not, maybe the other surveyor thought it was, and he just blindly started putting monuments in the ground in the wrong location. So yeah, they're the called for monuments in that vesting deed, but they still don't match the intent. Okay. If the found monument is clearly a mistake, it will not be held. That applies to this. And then this is a good one regarding senior title dispute. Just because, okay, let me see if I can think of a situation. So you have this parcel of land. And the landowner sells off the east half to Bob. Okay. Then he sells the west half off to Chuck. So Bob owns the east half, Chuck owns the west half. 20 years pass, Chuck and Bob get along, everything's fine. Chuck dies, leaves the land to his sons. His sons split the land in half, and they want to sell north and south to make some money. And now, instead of saying the north half of the west half, which would be this north half of the west half, and the south half of the west half, instead of saying that in the deed, now they start bringing in bearings and distances. And when they do, they go over here. And they're going to try to sell all of this. And there's a 20-foot wide discrepancy here, let's say. Okay. So this strip in here is now, if you go by the deed, if you just take this south half, the west half, having the meets and bounds of this, you would think, as that potential buyer, I'm going to get all this land. Okay. And the potential buyer of this north half, they're going to get all this land. Well, that's not true. This right here is the line. These two sons cannot extend their ownership into Bob's land at this point in time. Bob has senior title over this. They cannot take what is not theirs. Why should Bob suffer for a surveyor measuring 20 feet too much? Okay. So, and the surveyor goes and he monuments here and here and here. And he records it. And it's non-ambiguous. And it makes sense. And those are undisturbed monuments. And let's even say that they're natural monuments. They're all perfect, high priority, paramount monuments. All that being the case, they still cannot extend their ownership into Bob just because these monuments tell you to. Okay. That ownership's going to stop here, here, and here, no matter what. I don't care what the monument says. Bob can go out there and pull those monuments out and everything's going to be fine because that's his property. Okay. So that's what this says. Just because they're called for doesn't mean they hold. If there's an ownership title that dictates otherwise. All right. And then these are quick. These are just simple, good ways of identifying monuments. There's a lot of ways you can go out without finding a monument. There's a lot of ways you can go out there and try to decipher where that monument is or what happened to it and where the corner is that it was supposed to mark. Okay. And now we're into the fourth one. So we did intent, original, location, monumentation, measurements. These last two are pretty easy. Just 2 slides, but measurements. So now we have no monuments to go by. So now we're going to have to start using math to try to figure out where these corners are. The most certain rules. So when you're reading your deed, I will say that surveyor I worked for first, when I was writing all that description and putting to be set, he was doing everything else. And in hindsight, when I look back, he was doing everything else correctly. If he would have just left out those damn parentheses, he would have been fine. But he even went as far as saying he wouldn't just write out 200 feet. He would write out in words 200 feet. Okay. And the reason he was doing that, he told me, was because of this first rule right here, most certain rules. This is whenever you write a check, this is the reason why you have to write out in words the dollar amount, is because someone can easily just mistake and put a decimal in the wrong spot and change it from $200 to $2,000. But if you're writing out, it's going to be a lot more cumbersome for you to write out $2,000 as opposed to $100, right? So it's a good idea to actually do that, because when the judge looks at that, he's going to be like, no, this is definitely what the guy intended, because it took him 19 characters to write out what he wanted as opposed to 3, right? So you can assume with good certainty that that's what was meant. Measurements only assist in locating monuments. So I should change this. It shouldn't be it should be corners. So just like the monuments don't mark a corner, measurements don't mark a corner either. Measurements are just there to get you in the right direction and the right distance to get to that corner. They're just an indicator, and they assist you in doing that. They don't make it a definite. When in doubt, direction is assumed to be true. So if you don't have a bearing of basis, you're going to assume true north as opposed to magnetic north. Now, in meets and bounds states, it's the opposite. You assume magnetic. You do not assume true north. Direction and distances are to be run in the original order. I hear this a lot, and it's true. You're really supposed to go whenever you're walking those original footsteps and they call north, west, south, east. You really should walk in that counterclockwise orientation as opposed to the clockwise orientation. There might be a situation where that would be beneficial for you to go in the direction they're telling you. Okay. Distances hold over direction. But again, in meets and bounds, it's the opposite. So the reasoning by why distance over direction in PLS, I've heard, is because originally, so you had a surveyor holding the end of the chain and directing the I-man where to walk. So the I-man simply just drug a chain out there in the direction that the surveyor told him and held the chain at that distance. Or he held it taut, or she held it taut. So really, the surveyor was dictating the direction to walk. So the surveyor, who supposedly knew more than the I-man, was dictating bearing. The I-man was in charge of making sure that chain was taut. That was his job or her job. So the distance kind of relied on the I-man, not the surveyor. So they put more validity in the angle than they did. They put more validity in the distance than they did the angle. I don't know if I said that was meets and bounds or not, but I'm talking meets and bounds. I think I said public lands. Sorry. So meets and bounds, that was the reasoning behind bearing over distance. But in PLS, it's the opposite. It's distance over direction. And I don't know why it's done that way. Jerry or someone has any input on that, I'd like to know. But and then distances are assumed to be ground distances. So you're going to assume that they're going to be slope distances, ground distances, as opposed to horizontal. Okay. Unless stated otherwise. All this can be reverted if you state otherwise. Okay. It all depends on what your basis of bearing says, what your notes say, all that stuff. Okay. And then fifth on the list is area. Area is the bottom of the barrel. That's if you have nothing to go by. And a description, a poor description depicting this example would be like Billy Hudson's land being 25.3 acres. Well, you have nothing to go by with that. Okay. I mean, is his 20 acres shaped like this? Is his 20 acres shaped like this? Is it shaped like this? Is it shaped like, you have no idea what it's shaped like. All you know is it's 25.3 acres. And I like this example because they cared enough to bring it to the nearest 10th in acres, but they didn't care about anything else. Now, a lot of the time you see this because subsequent deeds told you what it is. So you have a piece of land and it's perfectly described out by meets and bounds in a deed. Then it's sold to, so this is George in 1962. And it has meets and bounds all the way around it, okay? And then George sells it to Tom. And he does the same thing. He just carries on that same description. And then Tom sells it to Kelly. And then when Kelly gets it, she might say, the land described in the deed from Tom being 93 acres. So it's kind of like a reference deed. So her deed's going to say all the land that Tom purchased from George in reception number 1234 being 93 acres. And then later on, Kelly might sell it to Paul. And that's when you get the crappy deed saying 93 acres with no reference to what else is going on. Okay. So if you just get this deed and you look at it, you're like, well, what the heck? You'd have to go back, chain of title, see hers. And now, oh, okay. So it's a reference deed. You go find this one, then you can find this one. Now you get your operative deed right here. This is your vesting deed, who currently owns it. And this is your operative deed, how the parcel was created. And this is what you want to get your hands on. That's going to tell you the real intent, hopefully. Okay. So you want to go by area as a last case resort. All right. Are there any questions? Let me go see.
We've had all kinds of sidebars in the chat as you kind of went along.
Yeah.
So let me unpin your thing, or go back to gallery.
Okay.
Let's see. Well, when you talked about walking the lines, right? That's when the GPS conversation come up.
Oh yeah.
George says with GPS, nobody walks the lines anymore. We just kind of walk to a point. So
yeah.
Yeah, everybody's got to click on the ad that Jerry was talking about, the Top Con ad. It's
oh yeah, I saw that.
Yeah, that's interesting. They don't talk about their technology. They just show you somebody holding the GPS rod up over a fence. Yeah, George,
Yeah.
do your research. Yeah, work with your title company and get all the history. That's that is something that Mr. Parrish even texted me over the weekend. Separates the difference between surveyors is expert researchers, just spending the time to actually find the right research in a lot of these scenarios that you just kind of talked about.
Yep.
Let's
okay.
see. Anybody can unmute themselves. Do you guys want to have kind of specific questions? I know there was some dialogue going on in the chat, but.
Well, maybe I should retire, but no, I'm so done with this.
You said you weren't even going to hang around the whole time, but look at you. You're still here. You sucked in.
Well, yeah, but you know what? I feel an obligation to the profession and to the younger people that are coming in, and hopefully there's lots of them. We need to figure out a way to do that for sure. Because I hate to say that at 74, I'm finally above average, but for age for surveyors. But you know what? Like I said before, I was blessed to have good mentors along the way, and they prepared me to take the exams. And fortunately or unfortunately for me, I passed them first try both times. But we owe it to those that we work with to help them promote this profession, because we provide a valuable service, and the next thing we need to do is learn to charge for it.
That's right.
Yeah.
We're working on that. And I will say, I did reached out to quite a few universities this week for part of a presentation I was doing, and every university came back with higher numbers than when I asked them a couple of years ago. So
it's good. Yeah.
Everything was really good. Couple more. Oh, okay. About the last question, do these rules discussed tonight apply to all states? And that's Jerry's talked about that in the chat here a little bit, and even on quite a few. Each state has its kind of different requirements, right? And sometimes different hierarchies on what's accepted and that kind of stuff. I think I don't know if Jerry went on mute, but you said even Wisconsin's kind of a little bit
yeah. You have to, a lot of it has to do with historical development and the cultural background. When you go out east with the meets and bounds states, the non-PLSS states, and the influence that the Dutch, the Spanish, the English, the French had on those areas. And then as you move west, you get more into the public land survey states, and you have kind of a different different mentality that's been kind of over time evolved. So there are generalizations that we can make, but you got to be really careful to say that this applies in all cases. There's always going to be the exception to the rule.
Yep.
For sure.
Yeah, and every state does outline, what their hierarchy is. This is very generalized. And I would say what I've discussed here is not going to lead you down the wrong. I mean, I can't think of any state out there that would hold a passing call as opposed to a locative call, or hold a rebar over a boulder. You know what I mean? So, I mean, we're talking in general terms here, but the big thing here is that I want everyone to really understand is that intent. It's the intent of that grantor and his surveyor. What did they intend on doing? And is that grantee going to be the beneficiary of that intent? That's the big question, and that's the big ultimate goal. So that's what I really wanted to have as the good takeaway here.
Yeah, good point.
Is that grantee benefiting from the due diligence of the grantor and his or her surveyor?
So in order to figure that out, you need to do your research.
Yeah.
To do it in depth, and then you need to do your field work, and you need to honestly apply that. And with respect to all the adjoiners, because you have as much obligation to them as you do to your client. Absolutely.
Yeah, that situation where
that's what makes this profession so hard to deal with as a professional, because you have an obligation to everybody, regardless of who's paying you.
Yeah. Your oath is to the public.
That was when you were running through on part of your slide where it was hold the DOT comment or DOT's survey monument does over that of a private surveyor. George jumped in on the chat and was like, I'm offended because I'm doing my job correctly every day. And you'd say, like, you're saying I'm not supposed to, put as much into that. So yeah, it was funny.
I'm not opposed to DOT in Nevada, but it was not too long ago that they actually decided that they needed a licensed professional to run their survey department. And
wow,
we lobbied for that for a long time in this state, and finally we got it, and we've got some good ones there.
Yep.
And I can toot my own horn and say that most of those guys there that are working in that department were working for me before they worked there.
Yep.
May or may not be a good thing. I don't know.
Well, in Wisconsin, and it's true in a lot of jurisdictions, state agencies are exempt from licensing requirements for their surveyors. For a matter of fact, when we went from right-of-way plats to transportation project plats about 15 years ago, the people that reviewed them in the district offices did not have to be licensed land surveyors, even though the people that submitted the plats had to be a licensed land surveyor.
Wow.
So it's one of those things, those exemptions that are built into law, they're historical with respect to that, are slowly changing, but they're not uniformly changed yet.
Well, and something else that needs to happen in this state is there's no requirement for NDOT to file plats or any information they do survey-wise in the counties that they work in. And that needs to change. They need to file their work. They need to be responsible and accountable for their work as much as the rest of us.
Yep.
Not that it's bad.
It's funny. I mean, the majority of what I do for the state is review the work of consultants who are private land surveyors. So, I mean, they're the ones that are setting the pins and doing the analysis, and and here I am just reviewing their work essentially. So I don't know why they give me more validity than them. You know what I mean?
Right. Yeah, exactly. Anybody, Chris, good comment in the chat about programs closing up. That'd be an interesting one too. Just figure out how many programs have closed in the last few years.
Yeah, no. Yeah. Maybe you're getting excited for the college you were at, but 9 other colleges closed down their their
Yeah,
program.
yeah, we'll have to check that out. I'll have to see if I can dig into that. Anybody want to unmute themselves, asking any other
They
question?
could always go to Great Basin. It's a good program
right.
and I'm happy to support it. And it's available online.
Yep.
You don't have to go full time. You don't have to be in person.
Mhm.
One of the requirements we had for licensure in Nevada was a college degree, and we didn't enact that until we had an accreditable program in place in the state, even though we have no population in the state. So we really rely on enrollment from out-of-state students to support that program, and hopefully they will.
Yep, exactly. That's awesome. Anybody got anything else? Good stuff as always, Dane. I appreciate it.
Yeah.
Don't forget.
Yeah. Thank y'all.
Don't forget to check out his book or the video series, either one. Yep.
Yeah. Thank y'all very much.
Of course.
I'll be in touch, Trent, for
Sounds good.
PEMDAS and quadratic formulas if you want.
All right, sounds good. Awesome,
All
guys.
right.
Have a good night, everybody.
See ya.
Have a good
See ya.
week.